This call is now being recorded.
Okay, hello, this is Randy Rosado. I'm speaking to you from the St. Lucie County Jail, and today is November 3rd, 2021, and this is my Jailhouse podcast. I'm here in Dorm 11 where I got moved yesterday because in Dorm 8 I was about to get killed. It's gangland over there, and a lot of crazy things happened as I've already shared. But here seems to be a little better. I know a few people over here, but I still have to be careful because now that I got this new PIN number to use on the phone and stuff, I have to be real secretive with it. It used to be just you had to cover your PIN because people would try to steal it to use your free call once a week. But now with these tablets, they could actually go into your tablet and use it for prepaid items like music and movies and prepaid phone calls. So they could literally just steal your money right out from under you. So and after yesterday, I think it's another reason, another perfect example why people don't trust police. You go to the officers for help and they turn it around on you, and next thing you know, you're the one in trouble, and it's unbelievable. And I'm not the only one who got in trouble, but the fact that I'm called a liar and it's turned around on me when my money got stolen, it's almost, I equate that almost to like having your house robbed because you left the door unlocked, and then you call the police and they charge you too because you left the door unlocked. So now you're an accessory or a principal or somehow part of the burglary. I mean, or even if the door was locked, if someone got a hold of your security PIN number on your alarm system, you call the police to report it, and they come over and charge you because somehow you messed up and were negligent or something. That's kind of what we have. Police aren't here to serve and protect anymore. It seems they're here just to charge and throw people in jail and keep bringing that money in, and that's the reality of it. But anyway, so I just want to go over something, and I'm really seeking some legal expertise, and I'm hoping to get some a legal perspective on this. I had more notes, but my case is so unusual because it uses this statute, Florida Statute 843.0855, which says, and you can look it up, it's criminal actions under color of law or through use of simulated legal process. Okay, so for anyone who's an attorney or anyone who's got access to like Westlaw and LexisNexis, you can actually search in Florida and you'll see there's no other cases there except for a Terry Trussell case in Dixie County. So I think it's 2014, the state versus Terry Trussell, and he appealed. And Mr. Trussell was charged under 843.0855, but he was charged under subsection 2. Okay, I was charged under 3 and 4. So there's still no other cases that have case law under subsections 3 and 4. Now the Trussell case under subsection 2 was for impersonating or falsely acting as a public officer or employee. And what he did was he actually worked for the grand jury in Dixie County and filed some documents, true bills and stuff. So he was charged per document that he filed, and he physically filed these true bills in person, and they knew who he was. And he was also using the courtrooms for what they thought were grand jury. At least this is what I read. I can't say for sure, so I want to say allegedly. But so instead of using it for the actual county grand jury meetings, he created his own private grand jury and was using it for that purpose. So his charges were quite a bit different. I know he got 9 years, but I think he did win a couple of counts on appeal, so I don't know. But anyway, the point is, other than that Trussell case, there's no other case that's ever gone to trial. So this is very unique. And this is really what I want to talk about today, because even though some of these points may not have been argued at trial, or at least, I tried to do the trial partly, which I didn't want to. I felt forced into it, and I was overwhelmed, so I turned it over to the attorney I've been having problems with all along, Sabu Gorgon. And, Mr. Gorgon was paid by the state $110,000 when he barely represented me. I was pro se most of the time. But anyway, he stepped in the middle of trial and never made this argument, but I did make it during pretrial, so it wasn't. So I felt like it was preserved. But I just want to talk about what this statute means, because under subsection 2 of 843.0855, it says a person who deliberately, under subsection 3, subsection 3, a person who simulates legal process, including but not limited to actions affecting title to real estate or personal property, indictments, subpoenas, warrants, injunctions, liens, orders, judgments, or any other legal documents or proceedings, knowing or having reason to know the contents of any such proceedings, documents or proceedings, or basis for any action to be fraudulent, commits a felony in the third degree. Okay, first and this may take a couple recordings, and again, I'm looking for a legal perspective on this because I don't claim to be a lawyer. I'm not very good at it, obviously, although I don't think there would have been any chance for me anyway, because all the local attorneys we tried to hire, some of the best ones in Lee County, from Robert Harris to Joe Villacavo and J.P. Galasso, they all said, you pissed the judges off. There's nothing we can do for you. And then I didn't hear back. I think Harris's office even said, we'd have to charge you too much money, and there's nothing I can do. You upset the judges, and I got to work with these judges every day. So we were screwed. No attorney would touch me. We tried over 50 attorneys. I initially had an out-of-county attorney who just was useless, and they don't like out-of-town attorneys there. So, but I was just kind of focusing on what the law says, and the definition of legal process, and I felt that this was important. The definition of legal process under this statute, which is 843.0855, paragraph 1, letter A, says the term legal process means a document or order issued by a court or filed or recorded with an official court of the United States or the United States, official court of this state or the United States, or with any official governmental entity of this state or the United States, for the purpose of, and I think this is critical, for the purpose of exercising jurisdiction or representing a claim against a person or property, or for the purpose of directing a person to appear before a court or tribunal, or to perform or refrain from performing a specific act. And you could read this for yourself. This is in my appeal, so I'm not going to just restate it. You can read. Anyone who's interested can read my amended brief and my reply brief, the handwritten documents, on the Randall Rosado blogspot site or wherever else it might be posted. But this is important because the state specifically mentioned the for the purpose of, and they highlighted it, for the purpose of exercising jurisdiction or claim. So my argument here, and I'm not going to get into every count because there was a lot of double jeopardy, but if you look at the information that was charged, now the amended information was on February 23rd, 2018, and the record, which can be downloaded right there on that site, is pages 299 to 304. And counts 1 through 8 were, say, on or about May 22nd, 2015, did falsely, it doesn't say me, it just says did falsely under color of law attempt to influence, intimidate, harass, retaliate, or hinder a public official or employee. Okay, so that's subsection 4, because the alleged victim there was a judge, John Duryea. Now, count number 2 was also subsection 4, same date and time, same exact action, and that was Linda Doggett. Now, then counts 3 through 8 were all subsection 3, because I guess they weren't technically public officials, and they were attorneys, I believe, and they were under subsection 3 for simulation of the legal process. The point is, those were all one single action, as the state showed in their exhibits. Matter of fact, it is, if you look at State's Exhibit 27, which is on the record, pages 1931 through 1965, and it shows that on May 22nd at 4:23:07 p.m., this document was filed. Now, this was a single document, which was, I believe, a motion. I think it was some kind of notice to take judicial notice. I don't know, some kind of judicial notice, right? And then attached to that were these alleged arrest reports filed by a man named Joel Soucy out of New Hampshire. I think he was in Massachusetts at the time. So Mr. Soucy was actually charged for the same act, but he was only charged with 2 counts, and he was actually charged for the same victims under a different subsection. So they're interchangeable the way the state is deciding to use it, and the appellate court is allowing this and not accepting my argument. And this is bizarre to me because, they're calling me a principal. They're saying that even if Soucy did it, they're blaming me for telling him to do it. So if I told Joel Soucy to jump off the Brooklyn Bridge and he did it, then I can be convicted for murder, apparently. So under Florida Statute 777.011, I was charged as a principal in the first degree. So that basically says that I could be punished just as if I had committed the act that the other person did. So Joel Soucy pled guilty to this, and he got probation time. Okay. Now, in the jury instructions, it said the principal must be treated as if he did the same thing as the other person did. However, they treated me far different. Or I stated, I'm just paraphrasing. The point is, they treated me far different than Mr. Soucy, and they charged me a whole bunch of times, but differently from, with a different subsection of that. Okay, so in addition to double jeopardy, my argument is really what I'm getting at here today, and this is what I'm looking for some expertise on because there's no case law. Is this an actual legal process? Because under the definition of legal process, like I just explained, it says a court of this state or the United States. I'm sorry, I got notes all over the place. All right, so it says a document or order issued by a court or filed or recorded with an official court of this state or the United States. So the document first has to be issued by a court of Florida or the United States. Okay? So now the charges were these federal arrest warrants that Joel Soucy signed, calling himself a private attorney general. We'll talk about that a different time. But they were signed by Soucy, but they were exhibits within the actual filing, and they weren't the filing themselves. In other words, those federal arrest warrants weren't filed into a state court because they couldn't be. There's no way to file them, but they were filed as exhibits. So if you look at that, not only do they have to be issued by a court of that state or the United States, which they weren't, right? The federal arrest warrants were not issued by a court, by a federal court. They were issued by Joel Soucy, and they weren't issued by a state court, obviously. Now, the state argued, well, they were filed or recorded into the court. Even though they were an exhibit, they were still filed into the court. Okay, so once you discover that, they have to overcome that they served the purpose of exercising jurisdiction or representing a claim. My argument was that these federal court documents filed by Soucy could not exercise jurisdiction in the state court, let alone exercise jurisdiction at all as an evidence exhibit to another filing. So this whole case, this whole charge was really a big sham. Now, I could get into, there was 19 charges altogether, and I can get into all of them, but I want to focus on the first 8 because that's really what my sentence is based on, right? They took each of those 8 counts and gave me 5 years each. 5 times 8 gave me 40 years for a single action for something that was not even a legal process when you look at the law. Now, I argued this in my appeal. The state came back and said that I'm interpreting legal process too narrowly. No, I'm interpreting it literally. That's why the statute offers a definition. So I really like to get an opinion on that because I feel like my argument has some validity, and I feel like the appellate court should have at least issued me a written order, which they've now denied on October 27th. They denied me a written order. They won't give me a written order when there's been no other case with these charges that has ever gone to trial. So I'm a guinea pig here. They're making up the rules as they go along so they could build case law around this bullshit statute that is so subjective that it allows them to do whatever they want. Not to mention that when you understand and it's my understanding, this is called a crime of mens rea, which is criminal intent. They have to prove that I knew that or had reason to believe that these were fraudulent documents. And the arrest warrants may have been, but I don't believe some of the other stuff was, because there was also other charges. All right, so counts 1 through 8 was a single act, and then there was count 12 on October 28th, which was a separate document, and then counts 13, 14, and 15 are the identical charge with the identical victim, and they just used the same thing 3 times, and I argued that in a motion to dismiss, and it was denied. Now they ended up amending that a couple days before trial. 2 weeks before trial, but this was months and months earlier. This was 5 months earlier, 4 or 5 months earlier. So that's, again, January 29, 2016. They took the same identical information and filed it in counts 13, 14, and 15, and they charged me 3 times for that. Then on February 25th, they charged in counts 16, 17, 18, and 19, they charged me 4 times for a single action. So really, out of 19 charges, there was only 4 separate acts that occurred. So again, we'll get to that with the double jeopardy argument, but that was ignored as well. So, I really had 2 arguments. Number one, there was no legal process to actually simulate. In order to simulate the legal process, you need a legal process. And my argument was, well, there was no legal process because those documents in question don't fit that description. So I just really hope someone can take the time and review my argument. Hopefully it makes sense. But that's really the nuts and bolts of it, the fact that you took an unrecorded federal document from Joel Soucy and you charged me 8 times, but it only entered to the court at a single point in time. But that document, again, cannot exercise jurisdiction in a state court. And again, can an evidence exhibit within a filing be a legal process on its own? And this is what I've been asking the appellate court. I understand if they were charging me for the actual judicial process, yeah, that might be a legal process because that's the filing of a document. But can they charge me 8 separate times for exhibits within that document? So that's really what I'm seeking. And again, this is just the beginning of really what my arguments were on appeal. But because, it's bad enough I'm being blamed for the actions of someone else and told that I caused them to do it. But the fact that they're subjectively deciding what they want to call a legal process and they have that ability, that's really disturbing to me. And this was all, matter of fact, if you look at the motion to dismiss, and unfortunately, you might I have got some hard copies, but the supplemental record isn't numbered properly, so it might not coincide exactly with my briefs. But if you look at the hearing from October 19th, 2018, when I have a discussion with Judge Margaret Steinbeck, I explained that
you have 1 minute remaining.
This probably isn't a legal process. And she clearly says, well, I don't want to go to trial on something that's not an actual crime. So that's the October 19th hearing. And then the motion to dismiss was heard on November 20th, where I make a very thorough argument on the record of why this isn't an actual legal process and no crime was actually committed. So anyway, I'd love to get some opinion on that. I hope someone can shed some light because it's such a new charge and it's just so rare. So thank you for listening. I think I've probably beat that to death, but I hope that makes sense. And I'll talk to you soon, and we'll get more into double jeopardy and some of the other things that I called out.